morning, Your Honors.
Good
Jennifer
morning.
O'Brien for the defendant on appeal, Herman Irene. With me is Dana Curran, who submitted an amicus brief on behalf of CPCS. As you know, the defendant in this case was convicted of armed robbery, and I think the main issue on appeal is whether the Commonwealth's introduction over the defendant's objection of a certain out-of-court statement or a statement contained in the defendant's medical records was erroneous and violated the Confrontation Clause and Crawford v. Washington. The statement in question here, there were two statements, but only one of which was admitted, was that the patient states that he was minding his own business while he was in a taxi cab when he got shot, and that was in one of the defendant's medical records, and this medical record was introduced into evidence.
Was it introduced for the truth of the statement or for some other purpose?
I would argue it was introduced for the truth of the statement, because if you look at the prosecutor's closing argument, the prosecutor does go and state that, you know, the defendant raised the issue that the defendant had gave different stories to the police and so forth.
Yeah, different stories, but that's not the... That's...
No, but he does say, the prosecutor says that, you know, and then he tells the doctors and the hospital that he's in a taxi cab minding his own business when he gets shot. You can take my prints, I wasn't in a cab, but I suggest to you he was in a taxi cab and that he wasn't minding his own business unless his business was robbing the taxi driver. So in this case, part of the statement, obviously that he was minding his own business, was not introduced for the truth, but the fact that he was in a taxi cab was introduced for the truth of the matter, because that was the main issue.
But doesn't that say to a doctor who's treating him that he's oriented in time and space? I mean, he didn't say I rode in on a spaceship or I rode in on an ox. He said I was in a taxi. That says something to the doctor that a doctor can consider in treating the defendant, doesn't it?
I don't think so, and that actually, it's a good point, because it was raised by trial counsel. In his medical records, it was clear that he was given morphine and a bunch of other drugs, so to speak. So defense counsel raised the issue of voluntariness and whether or not the defendant was, in fact, in his right mind, so to speak, when he was talking to the doctor in this case. He had testified himself that he had smoked marijuana laced with PCP.
Are we talking about the statement, or are we talking about the hearsay issue right now?
We're talking about both, but I don't think it is clear.
My question to you is, does the statement that he was in a taxi offer some value to the doctor who's treating him?
No.
Why not?
Because the doctor wouldn't do anything differently had he known the defendant had been A, minding his own business, or B, in a taxi cab.
Well, but if he had been doing something, like if he had said, I just came in on a spaceship, the doctor might do something considerably differently, wouldn't he? There would be some indication that he was either on drugs or that he was mentally ill.
But if he was mentally ill, he's coming in with a gunshot wound, so I don't think he would treat him differently if he was mentally ill or in his right mind. The reason he was treating him was a gunshot wound, and that was the reason, the whole reason why he was there. It wasn't a psychiatric evaluation.
But the way the doctor would treat a gunshot wound, the kinds of medicines that might be administered, could be affected by the doctor's perception of the patient as either being mentally ill, or the selection of medications might be different depending on how the patient presents himself.
Well, it might make a difference if he was mentally ill and was on different medications as a result of that mental illness.
So by saying that I came here, I was in a taxi at the time I was shot, that suggests to the doctor that he's not mentally ill. I mean, he appears to be oriented, so I'll treat him conventionally.
I disagree. I just don't think that the treatment would have been different if he was mentally ill. I think he was. It was an emergency situation. Obviously, they transported him right over to have surgery. So I don't think it was a psychological evaluation. I don't think it really would have made a difference.
When did this examination take place? That the doctor noted in the records about the taxi cab. I mean, when was that in connection with the treatment of the defendant?
It was prior to the surgery.
He'd already been at Lawrence Hospital, and then he was transported to Brigham, and this is the Brigham and Women's doctor. Or was this a note from the Lawrence Memorial?
No, it was the Brigham's.
Brigham. So we're talking about several hours after the shooting, probably, because, and so this was before the surgery. And do we know when the surgery happened in connection with
this
the incident?
statement?
Well, yeah. Can you place any of these things in a time sequence?
I don't have a time sequence for that, Your Honor. I know it wasn't a long period of time, but I know that when he did initially he was initially treated, he gave a statement to the nurse, and that's one of the things.
And that statement was out.
That statement was out, but I would argue that especially where this statement, that the record says that the doctor had reviewed the patient's chart. That initial triage or admission statement where it specifically asked him, do you have any stressors in his life? And he says, yes, robbed a cab. That this doctor, probably not the smartest statement, but this doctor should have been on notice, since he specifically says in his record that he did review the chart, that this doctor should have been on notice that this, might be a crime. And it really doesn't make a difference whether the defendant in this case was the perpetrator or a victim in the crime, since the doctors are required to report gunshot victims to both the
But that's a different law. Don't we have a policy of liberal allowance of statements by patients concerning their history, other than statements that clearly indicate liabilities, statements that are perhaps per se an admission of liability? And the defendant didn't just come in and say, I was just involved in a robbery. He said, I was in a taxi. There's nothing, doesn't that statement fall within our liberal interpretation of medical records, that we should allow doctors, statements made to physicians in the course of treatment, a liberal admission?
Well, I think in the course of treatment, but again, this goes directly to liability, and I think it has to be decided on.
I was in a cab goes directly to liability?
I'm sorry?
The statement, I was in a cab, goes directly to liability?
Well, it would, because in this particular case, the main issue
it's
was
incidental.
whether or not well, not in this trial. When you look at it, if you're just looking at the medical record in and of itself, but the way.
But from the doctor's perspective, it's incidental. It has nothing, the doctor has no idea that his being in a cab is any kind of an admission of liability.
At this point, probably not. That he was minding his own business or not minding his own business. But since he knows the police are going to be involved, the doctor knows that the police are ultimately going to be involved in this case, a reasonable person probably could know or should know that where the defendant was at the time that he was shot would be a question for the police. If somebody comes in with a gunshot wound, maybe not, what he was doing and where he was, it's going to be a question for the police, I'm sure. So I think this doctor should have known that this could reasonably be used in a prosecution, again, whether the defendant was the victim or the perpetrator of the crime. And in these cases, this particular medical record ultimately did come in under 78 instead of 79, and I think there was a discussion about which way this should come in, and it was defense counsel's argument that 79 should apply, and it wasn't for treatment and purposes. And the judge ultimately seemed like he agreed, but said, well, this is a business records anyway, so it comes in. So it looked like they were kind of using 78 to just circumvent 79 because 79 requires that it just be for purposes of treatment or diagnosis. So this is kind of.
Is it your position that business records are inherently testimonial?
Not all business records are inherently testimonial, but when there's a statement in those business records made by someone who could anticipate that there could be a prosecution or could be used in an investigation or prosecution, then absolutely. The record, it's clear that the record, unlike Melendez-Diaz, wasn't just introduced solely for the purpose of proving, an element in the crime, but I think you have to look at it a case-by-case basis, obviously, and instead of saying, the blanket assertion that anything that comes in under 79, it's a medical record and everything in that record is going to come in, or the other way with 78, say that if it's a business record that it's not going to come in. Here, there is a statement made by the doctor. The defendant didn't write his own medical record, so I know the Commonwealth is arguing that it's an admission of a party opponent and it is the defendant making the statement, but here the writer or creator of that record is the defendant. And there were some real questions whether or not the defendant made the statement. because he was on drugs at the time, or allegedly on drugs, and had been given drugs at the hospital. So I think that the statement is twofold. The first statement is that the doctor says, the patient told me this. That's statement number one. And that was definitely offered for the truth of the matter asserted. It was offered to show that indeed the defendant had made a statement to the doctor. And then the second part of that was the statement made by the defendant allegedly. So that was also offered for the truth in part and not in part.
Now, as to the hearsay element, put aside the testimonial issue, why is this case not dictated by Commonwealth versus Cine Van Tram, recently decided, which says that a business record may be admitted not for its truth, but simply for the fact that we can expect that the business accurately recorded what the person said? And why can't we say here that the business record exception essentially says we have confidence that the doctor accurately reflected what was said, that it was not made by anybody with a duty to speak the truth, so it does not come in on the business record for its truth, but it's an admission of the defendant, and therefore if you overlay the admission of a defendant with the fact that we have confidence that it was accurately recorded, that those two things together mean it's admissible. That's essentially what Cine Van Tran doesn't need to go the second part, because it was not an admission, but it essentially says the accuracy is imported by the business record exception, and then you add the admission standard, and then bingo, you've got an admissible statement.
Well, I think this case differs from that case for a couple of reasons. In that case, there was no conversation. My understanding was that the people held themselves out. It was the flight manifest that came in, and the people held themselves out, or somebody held themselves out as this particular person that traveled. Here, there was a conversation between the doctor and the physician, and it says in the notes that I discussed, with patients and so forth.
Is there any serious question that the doctor accurately reflected what the person said?
In this case?
Here.
Yes, I think, again, because the defendant was on medication, both legal and illegal.
That goes either to voluntariness or weight. But
well, he should have been cross-examined. I mean, I think that's something that defense counsel should have been able to ask him. How did he appear to you? What kind of drugs had he been given before you even spoke with him? And I think in the case you just mentioned, there was also a limiting instruction by the judge, and the judge specifically told the jury that what came in was, not for the truth, so to speak. It was just to show that somebody, truthful or not, held themselves out to be the defendant who flew. Here, there was no such limiting instruction. The judge didn't tell the jury that they can use these statements in the medical record just to show that he said it and, maybe gave an inconsistent statement. It was argued by the prosecutor that it was it was for the truth, that in fact the defendant was in a cab. So I think that's different. And again, this is the main difference is because it was offered for the truth, and that's both the statement made by the doctor and part of the statement made by the defendant. And most of the cases, there are cases both ways on this, but most of the cases where that have come out so far after Crawford and Melendez-Diaz, as far as medical records, they've come in under 79. So there really is no question, no statement regarding liability. So the issue hasn't been raised. I think had they come in under 79 properly and it was stricken, then we wouldn't be in this position arguing Crawford. I think that's what triggered it here, the fact that they were introduced under 78 instead of 79.
Now, the Confrontation Clause usually speaks about the declarant being available. Here,
I think that's the big question, who the declarant is, and
right.
We're arguing that there's two declarants. There is the defendant, and obviously his statement would come in. Had the doctor testified at trial, the statement definitely would have come in as admission of a party opponent. But we're arguing that the true speaker, the first speaker, was the doctor who says, patient states. He's talking about a conversation. It's an out-of-court statement made by someone to him that the Commonwealth had introduced into evidence at trial.
and is there any of these cases which have said that the declarant is the person who heard the statement as opposed to the person who made the statement?
Well, there is, I don't remember that. In Commonwealth versus Durin, and that case was a 2010 case where there's a substitute medical examiner, someone who performed the autopsy, and a different person who testified at trial. In that case, I would argue it's similar, because that is a report of someone, and the court reversed that case, saying that error occurred because the person who actually did the report was not at trial to be subject to cross-examination. So much like that, this is a report, and I would argue that it's even further in our case because there's actually a conversation. It's not just what the doctor did as far as examining someone.
But do you concede that if the declarant indeed is the defendant, the testimonial issue goes away?
If you don't look at the doctor as making a statement, yes. But again, that's not our position in this case. Thank you.
Thank you.
Good morning. May it please the Court. Kenneth Steinfield for the Commonwealth. I'd like to focus right in on Justice Cordy's first question, which I think is the key to this case, and that is, why was this evidence introduced at trial? It was not offered to prove the truth of the matter asserted. The statement by the defendant was, I was sitting in the back of a cab minding my own business when I got shot. The Commonwealth did not seek to introduce that statement to prove that he was in the back of a cab or that he was shot at the time that he was in the back of the cab. That statement was introduced explicitly and solely for the purpose of contrasting it with all of the other various inconsistent statements that the defendant had made that night about his whereabouts.
Right. But part of that was that he was in a cab that night. I mean, of all the places in all the world that he said he was in a cab, which is where you said he was.
Yes, that's correct. We did not say that he was shot, though, while sitting in the back of a cab. And I admit that this is the only statement that places him in the back of a cab, so one could say that it is different. But I would point the Court to the closing argument of the prosecutor, which shows quite clearly how he used that evidence. The way he structured his argument, at first he talked about why the jury should find that there was a robbery, and then he talked about why the jury should find that the robbery was committed by this defendant. He only mentioned the statement by the defendant to the doctor while cataloging the 5 or 6 different stories that the defendant gave, and he asked the jury to find the defendant not credible because that was one of those stories. The prosecutor never said to the jury, look, he said he was in a cab, and we say this happened in a cab, and therefore it's being offered for the truth. It was never offered for the truth of the matter asserted, and therefore Crawford and the Confrontation Clause have nothing to say about
The
it.
defendant testified, didn't he?
Yes, he did.
So that what you're saying that this is all to have the jury disbelieve the defendant's testimony?
Not just that, but there were various statements that came in through police officers prior to the defendant's testimony during the Commonwealth's case in chief, where the defendant had given various accounts of himself that evening. So during the prosecution's case in chief, there was properly admitted evidence of various stories. And so when this...
But when he was testifying, he also didn't put himself in the cab.
That's correct. So it both impeached the statements that came in through the police officers and also his testimony of what happened that night. And that was why it was introduced. And while there was not a limiting instruction, it was made clear by the prosecutor during his closing, as I said, that that is why the evidence was offered and admitted, and that's how it was actually used at trial.
But why couldn't it have been used affirmatively?
To show that he was in the back of a cab?
Yeah.
I think that it could have been.
Okay, so it
I
doesn't
think
make
that
any
it's not
difference.
hearsay. Right.
It could have been offered for the truth of the matter.
Right, for the truth of the fact that the defendant was in a cab that evening.
I mean, in Melendez-Diaz, the U.S. Supreme Court said that medical reports created for treatment purposes would not be testimonial under our decision today. And the standard applied by the court to determine whether a statement is testimonial fact is whether a reasonable person in the declarant's position,
Absolutely.
that's the doctor, would anticipate that the statement was being used against the accused in investigating and prosecuting a crime. The answer is no.
Right.
The doctor wouldn't believe that. He was there to treat somebody for a gunshot wound.
Absolutely, but I disagree that the declarant is the doctor. I think the declarant is the defendant who makes the...
How can that be? How can that be? So in other words, as long as there's a a document written somewhere with something that purports to be the defendant's statement, that the declarant is the defendant, and you can just admit the document?
Well, but wouldn't that
a letter written by a neighbor about what the defendant told him?
But if you say that the recorder, the doctor here is in the position of the person, say, at United Airlines.
What it was a police officer. You certainly couldn't get the police officer's report of what the defendant said, and you'd have to call a police officer.
That is certainly true, but
And
here
if
we
it
have
was a neighbor, you couldn't get a neighbor's letter in about, here's what the defendant told me. You couldn't just get the letter in without calling the neighbor, could you?
No, but this is a business record that's explicitly authorized to be admitted, and it contains.
How does that make a difference in who the declarant is? It may be it's admissible as a business record, but in terms of the declarant, how does that change?
Well, but if the declarant is the person who makes the record, who writes down the information, like the airline employee in Cindy Von Tron, then doesn't that eviscerate the business records exception? You'd have to call in each case the person who made the record and say, did you accurately make this record? The doctor here who made the report is in the same position as a clerk who writes down, accounts receivable. It's just, and he's including a statement that was made to him that was made by a defendant. So it's really, I think, just a question of totem pole hearsay.
All right, well, if it's a question of totem pole hearsay, I can understand that.
Yes.
But I don't see how it's admissible as a business record. It doesn't really matter who the declarant is.
Yes, that's right. That is my basic argument.
And then the second level of the totem pole hearsay may be that it was the defendant who made the statement, and therefore it's admissible on that.
Right. And if the doctor were the declarant, then it's certainly not a testimonial statement, so there's no Crawford issue at all. In fact, the evidence shows that the doctor was not aware that there had been a cab robbery. In the nurse's assessment, it does say robbed cab. Now, that statement was not offered because we did not know the source of that information. The nurse, and it says on the record, the prosecutor spoke to the nurse, and she said, I don't know whether the defendant told me that or I got it somewhere else. So the Commonwealth did not offer that. The doctor's report, at the very top of the doctor's report, it says, Dr. Baez states explicitly what he looked at and what he did before making that report. And the only document that he says that he looked at was the residence form on the patient's chart. So one can conclude from that he never looked at the nurse's assessment and had no way of knowing that a cab had been robbed. But even if he did, he would have no way of knowing, or no reasonable doctor in that position could have anticipated that the statement, I was sitting in the back seat of a cab minding my own business when I got shot, would be used in a prosecution for robbing a cab. It is unrelated to the gunshot wound. So even if the doctor were the declarant, it's not a testimonial statement, so there's no Crawford violation.
What do you make of the contention that, doctors are very aware whenever they're treating gunshot wounds that there is going to be police involvement?
Well, I think that may be taken into consideration when determining whether or not it was reasonable for a doctor to anticipate that the statement might be used. They're certainly more aware of it, but I think that would only get you as far as a gunshot crime. There's no way that a doctor would know that somebody who came in from a gunshot wound was going to be charged with robbing a cab. There's no evidence that he was under arrest for robbing a cab at the time. In fact, he had been placed in custody for outstanding warrants and had nothing to do with the cab robbery at that time. So doctors are certainly more aware because of their positions, especially emergency room doctors, that, and I think people in general know that a gunshot wound may very well have been the product or of a criminal act or have been in fact a criminal act. But I don't see how that causes one to conclude that the doctor would know. The standard is, would a reasonable person anticipate that the statement might be used in a prosecution of the accused for the crime? And by the crime, I think it would have to do with the gunshot wound. He would have no way of knowing that it was for some other totally unrelated crime that he may or may not have awareness of. There's nothing in the record that shows that he was aware that there'd even been a cab robbery.
How how did this happen at trial? Was there an objection to the admission of this record, and what was the nature of the objection? How was that handled?
That's another, no Crawford claim was ever made below. It was brought up on the second day of trial. They discussed motions in limine, and the defendant had a series of objections. He said that it was irrelevant. It didn't matter where he was. And he said that it was not admissible under 79 because it was not for the purpose of diagnosis or treatment. And the Commonwealth agrees that it was not admitted for that purpose.
So the irrelevance was also a 79 issue, is that right? Irrelevant to medical
Yes.
treatment?
Yes.
Yeah.
Yeah. And Judge Whitehead basically agreed that it's not admissible under 79, but he admitted it as a business record under 78. So whether the statement goes to medical diagnosis or treatment, I don't think is really at issue here. The objection, there was no Crawford objection. The defendant never said, the declarant is the doctor, you have to get him here. The word Crawford was simply never uttered. So the standard of review by this court is a substantial risk of a miscarriage of justice. Crawford claims can obviously be waived, and when that happens, that's the appropriate standard. I don't think the standard happens to matter in this case. I think it was harmless beyond a reasonable doubt in any case. The word overwhelming gets bandied about a lot, rather promiscuously, but I think in this case the evidence against this defendant was in fact overwhelming. The possibility that somebody else would have been shot in the back within 5 minutes and 2 blocks away from where this cab robbery occurred, and the fact that the defendant's hat was found at the scene with his DNA on it, and the cab driver picked him up right outside his father-in-law's house, and his wholly implausible story of his stroll around the streets of Lawrence, I think that even if this was a Crawford error, even if this did violate the defendant's confrontation rights, it is both harmless beyond a reasonable doubt and there's no substantial risk.
Even if it was a preserved Crawford error, you mean?
Yes, if there were a preserved Crawford error. Yes, and I might add that had there been a Crawford objection made below and the judge had sustained it, then the Commonwealth obviously would have just called the doctor. No one disputes, including the defendant, that if the doctor had testified, he could have said, the patient said to me, I was sitting in the back of a cab when this happened.
Mr. Steinfeld,
Yes.
assuming, and I think it's true, that medical records don't create a Crawford problem, but is a defendant entitled to have the keeper of the records offer the medical records under Crawford?
Pursuant to, I don't think so. It's certainly a statutory requirement. Both 78 and 79 have statutory requirements about the foundation that has to be laid for admission of the record. And there's no objection here on appeal that the foundation was not laid below for admission of the medical record as a business record. I'd point out that there is no claim on appeal that 79 and 79G provide the exclusive avenue for admitting a business record. That issue is not before the court. It has been held, and Dean Broden says in his evidence book that a hospital record can be admitted as a business record as long as the requirements are met, and I think that that was the case here.
Now, you said that it was not admitted as a medical record.
That's correct. It was explicitly admitted under 78 as a business record.
And are you saying it is not admissible as a medical record, or that it was simply not admitted as such?
The latter. I think that Justice
I thought you agreed that it wasn't admissible as part of the diagnosis and treatment.
I do believe that it could have been admitted under that, though the Commonwealth did not insist on it because the judge admitted it as a business record. I think, just as Justice Spina was stating earlier, I think that it could be relevant to diagnosis or treatment. There's another point. The doctor might want to know the position of the defendant's body when he was shot. That could certainly assist in his treatment.
But in any event, Judge Whitehead was concerned
Right.
about it.
Right, so the defendant won below, and we don't contest that. The defendant won. This is not going to be admitted as a medical record. So whether or not the statement was for purpose of treatment or history is not at issue here. It's just a business record that contains a statement. And so as I said, it's a simple question of totem pole hearsay, and the defendant's statement comes in both as that of a party opponent and because it was offered for a purpose other than the truth. I'll be happy to rest on my brief for the remainder of the issues unless the members of the court have any further questions.
Thank you, counsel.
Thank you.